Hello, everyone, and welcome to the Animal Legal Defense Fund's Animal Law Academy. My name is Megan, and I am one of our events associates. Today, we will be discussing the ethical and legal quandaries of animal cruelty in the digital age. Before getting started, a few housekeeping notes. We will have a brief Q&A at the end of the presentation. To submit your questions, please use the Q&A feature at the bottom of your screen, and we will try to get through as many questions as we can. This webinar does offer closed captioning. To turn on, please click the caret icon next to the CC button at the bottom of your screen and select Show Subtitles. Joining us today are Managing Attorney David Rosengard and Pro Bono Manager Taylor Waters. As Managing Attorney in the Animal Legal Defense Fund's Criminal Justice Program, David works with stakeholders across the criminal justice system to pursue justice on behalf of animal cruelty victims. As Pro Bono Manager, Taylor promotes animal law through the Animal Legal Defense Fund's Pro Bono program. Thank you both for sharing your time and wisdom with us today. I'll pass it over to you, Taylor, and then see everyone else back here for the Q&A at the end of the presentation.
Hi, everyone. We're going to be talking about something super controversial while I'm talking. It's cute animal videos. So while we go through this, I want you to consider a few things. Why do humans and why do you enjoy watching animals and animal videos? Why do humans tend to infantilize the animals we see and have no relationship with in our lives? Is this different than infantilizing the animals with whom you do have a relationship with? So, for example, if my dog Betty were awake right now instead of in a big cozy pile on a chair, I would tell you all about what a beautiful baby girl she is. Would you know animal cruelty content when you see it? Are there differences between watching live streams of wild animals in the wild versus curated monetized content? And the big one, is it ethical ever, sometimes, never, to own quote unquote wild animals as exotic pets? So these are some headlines that were taken from the time of the sleeping loris viral video phenomenon, where the internet exhibition and viral content of slow lorises, where you'd scratch them and they'd pop their arms out, and it was really cute because they had these enormous weird eyes, was actually fueling wildlife trafficking of slow lorises into the exotic pet trade and cruelty upon the slow lorises as people sought to recreate these videos that were portraying them as cute and cuddly, when in reality they were terrified, and their defense mechanism when they're scared is to make themselves big. So as we all know, everything on the internet is driven by algorithms. It's not just what people like in general, but you get content that is what you want to watch specifically. So for example, the second that you see a Noodle the Pug video, and Noodle's adorable, rest him, it tells them that you like dogs. So you'll either get more dog content or more animal content generally, and every selection that you make with content engagement gives you more of what you want and down into an ever finer niche of video content. And so these algorithms also are really good data sets to show what content people like the most. And studies have shown, we're going to get into it a little bit, that the animal must be cute, but the animal can't just be cute. The animal must be baby. Can't just be baby, though. Has to be anthropomorphized to some extent. Bonus points if you toss on a funny hat. I will send you, if you would like, videos of snakes, if you don't think snakes are cute, with funny hats on them, and instantly increases the cute factor of any animal, especially snakes. So what does that mean to infantilize wild animals, and why is it important? So infantilized animals tend to be the most exhibited in the digital content and physical worlds. A really good example of this are pandas. My partner and I have disagreements on pandas regularly. These aren't his words, these are actually from a study, but he would agree with this, that pandas are giant babies who are terrible at sex, dependent upon humans for their very survival, quote unquote, wobbly little toddlers with whom we must nurture lest they go extinct, which isn't really true. They're a wild animal. They are going extinct because of predation on their habitat and moving into these highly micromanaged lives as they lose the land that they would have lived on. So conservation for pandas tends to focus entirely on captive breeding efforts that are heavily filmed and distributed. So it changes the entire perception of what pandas are and whether they're even wild animals. So enter our digital world and anthropomorphized stories. So one of the things that is kind of the central theme here is understanding the negative impacts and very unintended consequences of internet content, particularly that aimed at viral animal videos. When I first started giving this presentation, I would talk a lot about the COVID pandemic because it was of that time to some extent, but it still relates now that when people are consuming a lot of online content or even just a little online content, you tend to be searching for some level of communication, connection with the outside world, with people that you relate to. Almost everyone here, I'm sure, is an animal person. So you're searching for connection, not just with other people who like animals, but maybe the animals themselves. And what does that mean for the kind of content that you're consuming? So our search for connection is inadvertently fueling industries like the illegal wildlife trafficking trade and the active suffering for likes, shares, and reposts. That's a lot of content. I don't expect you to read it all. It's okay. So animal exhibitors tend to use social media and cross-posting to make money. They're getting ad revenue. They might not just be getting ad revenue. They might be breeding the animals and then they're making money off of that as well. So they're exhibiting animals exclusively in a digital sphere without complying with the relevant licensing requirements with the country or jurisdiction that they're in. During the pandemic, platforms saw a surge of not only new users, but increased usage among existing users. So these are people who are new to the platforms, they're using it, they never used it before. And the people who are already there have been using it more since, and that has sustained since after COVID. So the usage when life went back to normal-ish has not dipped, it's sustained itself. So most of those content creators who solely exhibit in the digital sphere were very rarely, if ever, properly licensed to actually exhibit animals. And we'll talk more about the requirements for that in just a second. So by allowing this much unregulated, wild content of social media, not just social media, it's really TikTok, it's really YouTube and QQ, are causing a proliferation of normalizing the keeping of wild animals in people's homes in an unregulated sphere. And so how does that promote the exotic animal trade? How does watching a video of a sugar glider or a slow lemur promote exotic pets? These are wild animals. The typical term is exotic pet, but there are wild animals that are normalized into living in someone's home. So there was a YouTube study done, is specific to the platform of YouTube, and it was determining whether the platform encouraged or enabled animal trafficking via engagement with cute animal videos, and they found that it did. The content that featured primates and big cats had the most positive user engagement. Those are the likes, those are the subscribes, but not just that, they're the comments. And when you really dig into the comments, you can see what is speaking to people about these videos and whether they're at the point mentally where they're willing to take that next step and purchase a wild animal. So interactions that featured normalizing the keeping of exotic animals in homes in captivity were extremely prevalent, but the engagements were even more telling. The number one word was cute. Number one across the board, cute. Up next was precious, adorable, baby. These are all words that we would use to describe domestic animals and human babies. So it's this infantilizing wild animals, taking the wild out of them, and anthropomorphizing them in a very diminutive way. So the cute factor substantially enhanced the desirability and likelihood that a consumer acquired an exotic pet. So people weren't out there buying, I can't think of an ugly animal, I'm sure there is one, but they were buying the animals that they felt the most adorable, the most cute. And so my brother, small anecdote, was part of this problem. He went and bought a sugar glider because he saw a cute video about a sugar glider, thought it'd be fun. Realized that sugar gliders are extremely noisy, especially at night. And then it's the unwinding of that purchase. So now you've watched a cute video, you've given them ad money, you've purchased one either from them or from someone else, and now you realize you can't have it. So you have to surrender it to a shelter that may or may not be equipped to handle exotic animals. So it's creating this kind of weird Ouroboros of cruelty that's really unintended by the consumer, by the viewer. So cute animals, this is a really fun fact, have been an integral part of YouTube since the beginning. The first video ever shown on YouTube was an exotic animal. And so let's talk a little bit about the incentivization to fix this issue. There isn't one. It's really, I get into solutions. I promise we end up on a high note, but there really is no incentive for either the content creators or the platforms or the government to regulate the content. For one thing, it's almost impossible to regulate and govern the internet. It's really hard. I don't know anybody that has the resources to do that would actually want to. So with YouTube and other platforms creating this system where the more money you get and the more exposure you get, the more videos you have to produce. So you have to constantly be producing content. The platforms get money from their content creators who get money from the users via ad revenue. The government gets money from taxes. So either platforms or the government are both incentivized to keep these practices going in the form of millions of dollars. But what can the platforms do? They can strengthen their policy, sure. They can flag content that includes wild animals as exotic pets, sure. They can remove that content, absolutely, especially if it features free handling of exotic animals, unlicensed exhibitors, or otherwise illegal content where the video is captured. The problem with all of these platform-centered solutions is they're really hard to actually enforce. For one thing, you're dealing with millions of videos, frankly, not just the ones that are already in existence, of which there are multitudes, but the ones yet to come. It's just so burdensome that there's no meaningful moderation policy that could govern that much content. Beyond that, you're asking normal people who get this job to moderate whatever platform to take that mental burden of really scrutinizing everything they see for cruelty, which leads to burnout and other issues for the moderator. So that's platform-centered solutions are challenging. It's really difficult. And we talked a little bit about this a minute ago. It's this circle of incentivizing as much content, as much cute content as possible. And the average, it's estimated that YouTube earns 12 million from animal cruelty content, with the creators themselves likely earning 15 million aggregate, so not just one, but aggregate from cruel content. And I can send the references to anyone if you're interested in seeing that too. So I have some partners with the Coalition for Asia Farm Animals Coalition. I'm running over time. I will hurry, I promise. That found that over 13 months, there were 5,480 videos on social media platforms that promoted animal cruelty. These are just what they were able to find. It was mostly monetized, and almost 80% of the cruel content involved birds, companion animals, wildlife, reptiles, snakes, and primates. Most of the content was considered obvious and intentional, so these aren't even considering the more subtle versions of cruelty that we were talking about, scratching the slow lorises or scaring the heck out of cats with cucumbers. These are open and obvious forms of cruelty. The SMAC report found that primates were specifically infantilized by dressing them up in children's or dolls' clothing, scolding them as though they're children who had done something wrong. Not that it's right to scold your children like that either, but specifically withholding milk from baby macaques. And in one instance, a macaque was punished for breaking a bowl by being forced to stand straight against a wall wearing doll clothing. At the time this report was compiled, it was viewed over 500,000 times, and this was a year or two ago. So compared to licensing and laws, what exists? Enforcement does not exist. I will say that at the outset. Where regulations exist, they are not enforced at all. In the United States, we have the Animal Welfare Act, which is enforced by APHIS, which is a part of the USDA. And in theory, under the Animal Welfare Act, anyone who exhibits a certain number of animals for profit should have a license. And that sounds an awful lot like exhibiting animals on YouTube and TikTok. However, few creators have a license despite exclusively digitally exhibiting their animals and having the requisite number of qualifying animals. So APHIS does not enforce the Animal Welfare Act against digital content creators, despite the plain language that would include them in that definition. UK takes a completely different reaction. In the UK, digital content exhibition is specifically enumerated in their licensure. You have to be licensed where the content is created, and individuals and other organizations can enforce the welfare breach. So several organizations do, and any new organizations that want to have that option because the tools exist. we'll briefly touch on China because this is a comparative piece of work that looked into like good, middling, bad. And China is weird in the sense that it has a lot of laws that would, in theory, include the exhibition of wildlife, especially in the digital world. The problem is China doesn't have a broad animal cruelty law. So David will talk a little bit more about this in a minute. And it's that darker end of the tributary commerce streams that we're talking about, where animal torture is frequently filmed and shared on QQ and other regional platforms. Legal Daily, a Chinese news outlet, found a flourishing underground market where abusers were paid for producing clips or live streams of torture. And China accounts for nearly 80% of TikTok's revenue. So, with no comprehensive animal cruelty law, a lot gets away and a lot really sneaks under the radar, even into the very open and obvious forms of cruelty. So this is a quote from T.S. Eliot's Four Quartets. I highly recommend anyone read it. I would posit that T.S. Eliot is not incorrect here, that humankind cannot bear very much reality, that our drive to be voyeurs into these lives of animals tends to negatively impact their life, whether it is through these tributary industries of being bred and sold and specific monetization of videotaping them, but even in the more subtle ways. So a lot of video content that centers around animals that one would not even immediately think of as cruel are those fake rescues. So these are people that are making money off of ad revenue. They're not having any part in tributary industries, but they're putting animals in peril to then rescue them and videotape themselves as the rescuer. And so this exists outside this Ouroboros of exploiting animals via breeding, buying, selling, hunting, trafficking, but it hits on content creation. So think about the underlying point of the animal content that you're consuming and not just what's on your screen, but what's behind that screen. We talked a bit about the incentivization of who should actually fix this issue and why platforms are not the best bet. Governments, frankly, don't have the ability to enforce these rules either. But what about AI? So there's a couple of different AIs that are working in this sphere. Wildbook is one. It's currently being used for wildlife conservation, which is awesome. And it works to identify animals in surroundings, and it can be retooled to learn to identify instances of cruelty based off of what's going on with the animal. And there's another one that's being used in kind of a humane washing way to understand the health and psychological welfare of pigs while they're in an animal agricultural environment. And both of these can be retooled and used to sift through all of these videos, play the police, internet police, and pull back and remove the content that does support wildlife trafficking and both implied and explicit cruelty. Thank you. Please connect with me later. I'm happy to answer questions and just chit chat about these topics in any spare time. Dave is now going to take it away with kind of the darker end of the same stream.
Excellent. Oh, that is not the screen. All right. And hopefully you are all now looking at a screen of a PowerPoint. And yes, it is going to be the darker end of the spectrum. I appreciate the T.S. Eliot quote, but sadly, my half of our presentation is going to be more along lines of W.H. Audin's Shield of Achilles. It's going to get grim, y'all, because we are going to be talking about free speech as it applies to depictions of animal cruelty. So what are we going to be doing for the next 20 minutes? I'll be doing a brief overview of relevant free speech law so that we know what we're talking about. My apologies for those of you that are going to get law school flashbacks. I'll be going through some of how that relates to depictions of violence against animals. So videos or photos of not animals being displayed in a cute manner in the fashion that Taylor talked about, cute, albeit exploitive, but rather just explicitly cruel, knowingly cruel conduct, egregiously cruel conduct. I'll talk about how that poses a constitutional conflict in terms of how we address it in the United States, and I'll go through some ways forward. And all of this is in the framework of course, an animal-forward jurisprudence. That would be a jurisprudence that says that animal interests can be recognized and weighed as legitimate by the law, because that's what we are all about in the field of animal law and here at the Animal Legal Defense Fund. Final note, as I've been talking about what I'll be covering, you may be wondering, am I going to be watching some really awful videos or seeing some horrible images? You won't. So the content warning on this is that I will be discussing some pretty viscerally gruesome stuff, because with due acknowledgement of seminal first wave punk band The Exploited's breakout song Sex and Violence, that's what we're talking about today, is sex and violence and animals on the internet. But I'm not going to be showing you that content, both because a lot of it is in fact super duper illegal, and because it's been my experience that when people have these egregious images put in their faces, our emotional reaction can make it hard to process the content that we're talking about. So, the First Amendment. We're not talking about the entire First Amendment, we're just talking about the speech freedom portion. That would be that the government shall make no laws abridging the freedom of speech. But this prohibition is not absolute or unlimited. No more so than any other constitutional right is absolute or unlimited. So the question is always, when the government tries to restrict speech, how narrow can that law be? How restrictive can it be? And that's going to depend on the level of scrutiny we use. So for strict scrutiny, the question is the government addressing a compelling interest and doing it in a narrowly tailored fashion? For intermediate scrutiny, is this an important government interest that's substantially related to the issue at hand? And for rational basis review, it's simply, is the government aiming at a legitimate interest, and is the law they're passing, the speech restriction, reasonably related? And the relevance here is, for protected speech, we are almost always going to be in strict scrutiny land. The question is going to be, is the government aiming to deal with a compelling interest, and is their speech restriction narrowly tailored to do that and nothing else? If we are in unprotected speech territory, then it's simply rational basis review. Does the government have a legitimate interest in restricting this speech, and is the restriction reasonably related to that interest? And all of this gets to a core animal law implication, which is, how compelling is the government's interest in animals being free of unlawful cruelty at human hands? Because when we're talking about videos or pictures of animals suffering at human hands, and the government trying to restrict that, when we apply these levels of scrutiny, when we apply the constitutional framework, at some level we have to ask the question, how important is that animal interest? So, a little more background on freedoms of speech. Again, they are not absolute. You can have restrictions on content. That's almost always going to be strict scrutiny. You can have restrictions on time, place, and manner. The classic "you can't yell fire in a crowded theater" is about that. There are some places where you can yell fire. An environment where you're going to cause a crowd to unnecessarily stampede is not one of them. And then there is unprotected speech, which again gets rational basis review. Unprotected speech includes fighting words, kind of, sort of. That's largely fallen off in modern usage, much as profane speech has. So it really is about defamatory speech, obscene speech, and in 1982, the courts discovered child pornography as a new category of unprotected speech. And it's important to note here, this is non-obscene child pornography. So obscenity has always been unprotected speech. In 1982's New York versus Ferber, the court determined that non-obscene child pornography was also unprotected for a few reasons. One was that it's inherently harmful. You can't produce child pornography without engaging in child sex abuse. And that harm is not only instant, it not only occurs when the child is abused, but the harm happens every time the video is abused. A child survivor of abuse that was filmed and distributed has to live with the knowledge that there are people out there watching their abuse happen over and over again. And in the court's analysis, that is an ongoing harm to the dignity of that person. And the court also says, look, the benefits of child pornography if any actually exist, greatly are outweighed by its harms, and that we have to restrict the speech to deal with child pornography itself, that people producing this do it in hiding, and that therefore the best way to address it is to eliminate the market for it. And finally, the court says, look, we don't have any historical record of child pornography being protected, so why would we think it's protected speech? And this inevitably leads to the question, are there other unprotected speech areas that might be discovered? And specifically, what of speech harmful to animals? And here we engage with our first interlude on what kind of speech we're talking about. A lot of the conversation is going to circle around what are known as crush videos. These are images or films featuring the erotic crushing or mutilation of animals. Typically, this is done by a female-presenting performer who maintains a sort of dominatrix-style pattern while she harms the animal. You like that, you deserve that, and so forth. And what's going on with crush videos is the audience for them typically projects themselves into the place of the animal being abused. So it is a way for someone who is sexually aroused by the prospect of being crushed, mutilated, or killed to engage with their sexual fantasy without actually being crushed, mutilated, or killed. Instead, an animal has to suffer that harm. I'm going to skip soft crush versus hard crush in the interest of time, but ask me about it in Q&A if you're interested. And crush videos have been around for a very long time. They date back to at least the 1950s, but they've been greatly facilitated, of course, by photo and video technology as well as the internet. The fact that you can make these using handheld equipment and distribute them through the internet has really led to a boom in crush videos. And so in 1999, Congress passed the first law to try to get at this. It prohibited the creation, distribution, or possession, so making or trafficking, in recordings of animals being intentionally and illegally maimed, tortured, wounded, or killed, unless there was, and the law then gave a variety of exemptions: religious, scientific, educational, journalistic, historic, or artistic value. Now, President Bill Clinton, of presidential cat socks, who you can see there in the photo, being a lawyer himself, looked at this list and said, you've forgotten obscenity. Obscenity is really important here because obscenity is the speech that's unprotected. And so to regulate this, we really need to target obscene speech. And so in Clinton's signing statement, he said, this only applies to obscene speech. But of course, presidential signing statements do not have force of law. And so very shortly, the Department of Justice took it upon themselves to prosecute Bob Stevens under this crush video law. Now, Stevens was not actually producing or trafficking crush videos. He was producing and trafficking in videos of dogfighting. And these videos may or may not have been legal in the time and place they were recorded. That doesn't really matter for our purposes. Stevens raised a First Amendment defense, arguing that his videos were protected speech and the government couldn't regulate them in the way they were. The government argued in response that animal cruelty, violence against animals, should be discovered as a new unprotected speech category. The trial court said, yes, we agree with the government. Unprotected speech includes obscenity and child pornography and animal cruelty. The Third Circuit disagreed and would have held that preventing cruelty to animals is not a compelling government interest. So this is clearly teeing up a question of major importance to the animal movement. And that gets decided by the US Supreme Court. And the Supreme Court says, first, animal cruelty is not an unprotected speech area. Why not? They say, well, first, it's because whether the speech is low value and high harm isn't dispositive. The court says, yes, violence against animals isn't very valuable. And yes, the harm is there, but that's not the sole issue we look at. Instead, the court spent a lot of time discussing how there is no lengthy historical tradition excluding depictions of animal cruelty from freedom of speech. And this is interesting because, as you may recall in Ferber, in the child pornography case, the court says there is no history of accepting child pornography. Here the court is saying there is no history of excluding violence against animals. And that really shifts the burden and really expands or narrows the likelihood of an area being treated as unprotected speech. And I'll discuss more about that in a moment. The court doesn't rule on whether there's a particular interest in preventing cruelty, although Justice Alito, in a very strident dissent, says that, in his opinion, preventing living creatures from experiencing excruciating pain for entertainment is, in fact, a compelling government interest. So, Congress takes another run at this in 2010 under Obama, pictured with presidential dog Bo. And this law applies to amphibians, birds, mammals, and reptiles. It prohibits creating or trafficking in images of animals being purposefully subject to serious bodily injury when those images are also obscene. And then it has a list of exemptions. And it's not long before this law gets put into effect and a prosecution is mounted under it, because after the Supreme Court ruling in U.S. versus Stevens, crush videos exploded in open trafficking on the internet, because it was well known by people making and distributing these films that there was no law against it. Enter U.S. versus Richards and Justice. And here the defendants were charged for making crush videos where crustaceans, birds, kittens, and puppies were all tortured to death. And the defense argued that this was not obscene conduct in the sense that the constitutional First Amendment analysis uses the word obscene, because it wasn't sexual content. When we talk about obscenity in the context of American constitutional law, we are really talking about erotic content that is sexual. And here the defendant said, look, you can't see any more of the performer than you would at a beach. In fact, you see less than you would at a beach, because in addition to wearing a bikini, she's wearing knee-high boots and a mask. And in fact, you don't see any sex organs at all. You just see animals being tortured to death. And the trial court agreed with that. The trial court said, what we have here are videos of violence against animals, not sexual content. And relying on existing Supreme Court precedent, Brown versus Entertainment Merchants, violence is not unprotected speech. That was a case where the court held that violent video games were protected. That violence was not a new area of unprotected speech, much like animal cruelty is not a new area of unprotected speech. Now, the Fifth Circuit reached a different conclusion. The Fifth Circuit starts off by framing preventing animal cruelty as at least a substantial government interest. So maybe not compelling, but pretty good. And the Fifth Circuit read the law's use of obscene to mean obscene in the way constitutional jurisprudence uses that phrase. And the court finally said, while this usually refers to obviously sexual acts, it could include lesser sexual conduct. But the court didn't really explain why, and I think I figured out what they're relying on. So I think the unspoken precedent the Fifth Circuit is relying on here is 1966 U.S. versus Michigan. This is a Supreme Court case dealing with what was a prosecution for a bookstore in New York distributing queer-oriented BDSM pornography. And the defense argued, much as U.S. versus and Richards did, or rather much as Richards and Justice did, that their content wasn't obscene because it didn't involve sex. It just involved BDSM activity between same-sex couples. And the defense made the bold argument that this wasn't something that would appeal to the average person's sexual interest. Instead, most people would be sickened and disgusted. Again, basically the argument that was being made by Richards and Justice. And the Supreme Court rejected that. The Supreme Court instead modifies the prurient interest rule, the relevant portion of obscenity analysis that looks at sexual content, and says that where the material is designed for and disseminated to and I'm going to use the Supreme Court's language, a clearly defined deviant sexual group, rather than the public at large, you're going to look at not whether any average or random person would be turned on, but you look at whether the intended audience would find it erotic. And the Supreme Court goes to a great deal of trouble to explain that the gentleman, the individual sitting on the Supreme Court at that time, they don't find any of this erotic, but they're willing to accept it as obscene. I leave as an exercise to the reader whether the Supreme Court is protesting a bit too much in explaining how non-erotic they find any kind of queer content. Point is, this is the precedent that I think is operational here. That's the backstory for why I suspect courts aren't being a little more clear on what the precedent is, because it's not a terribly savory precedent in this day and age, but it is, I would argue, still good law. So leaving aside those parochial notions that led the 60s court to reach that conclusion, we find ourselves in a place where the Fifth Circuit upholds prohibition on crush videos as obscene, not because the people making those videos necessarily find them erotic. I can tell you in this case, Richards and Justice, the two people making and selling the videos, were not themselves erotically fulfilled by this conduct. They were just doing it as a form of sex work. It was just a job. And many people who watch these videos do not find it erotic, but there were a lot of people on the internet who were happy to pay top dollar for it. In 2019, Congress went one step further to try to target the underlying conduct. So up until now, it has been illegal to make and distribute these obscene crush videos, but actually crushing the animal was not a federal crime. And in 2019, that changes. The PACT Act makes it unlawful for any person to purposefully engage in animal crushing when there's a Commerce Clause trigger. You need a Commerce Clause trigger to allow the federal government to have jurisdiction. So in other words, purposeful crushing that involves crossing interstate lines, international commerce, or trafficking in and out of an indigenous reservation. Animal crushing is still serious bodily injury, and we still have a list of exceptions. And now we come to the present day. Hard crush, i.e. crush of mammals, birds, and fish, has largely retreated to the dark web and gone into hiding. But we are seeing cases of sexualized torture, where animals are having their genitals burnt, cut, or otherwise injured, and some of that is being prosecuted under the classic crush video law, under the theory that it is eroticized or sexualized content. I think there's an interesting constitutional argument about whether that works. It's going to be very fact dependent. There are certainly some cases where the defendant is sexually torturing animals because of an erotic interest on their part, and filming and distributing that. There are also cases where I think it's fairly clear that the defendant is torturing the animal to cause pain. They aren't really interested in sex vis-a-vis the animal at all. And then just this summer, the BBC broke the news of an international bespoke cruelty network. This is a network of individuals, largely in the United States and Western Europe, who were using various encrypted chat apps to order bespoke cruelty videos from Indonesia. They would get in touch with individuals in Indonesia. They would say, we're going to offer you this amount of money to find a monkey and torture the monkey in specific ways. And there are individuals involved in that ring, both in Europe and the United States, who have been charged. But the question, I think, becomes, what theory are they being charged under? So I want to briefly, in the time remaining, dig into what's going on with these bespoke cruelty networks. This gives you an example of the kind of requests that these networks are fielding. Monkeys being put into boiling water. Many of these monkeys are the very kind of macaques that Taylor talked about being featured in punishment videos. And in testimony from people involved in these bespoke cruelty rings, they describe how the algorithm, the same algorithm that routes people from cute animal videos to increasingly exploitive cute animal videos that Taylor described, can route people towards increasingly vicious cruelty videos. If someone, for example, displays an interest in watching a macaque monkey being punished, the algorithm will begin to figure out they have an interest, they enjoy watching monkeys suffer. And that may route them more and more towards videos of bad things happening to monkeys. Eventually, you end up in a video where the comments section will direct you towards encrypted applications, private chat rooms, or the dark web, where you see everything on your screen going on. We have monkeys that are being subject to pure physical torture. We have monkeys that are being subject to sexualized torture, such as sodomy. We have monkeys that are being burnt, cut, starved. And we have a certain interest in monkeys displaying psychological suffering, displaying pain, displaying horror, displaying shock, and displaying resignation. And this is, and I cannot emphasize this enough, truly disturbing content and absolutely would constitute animal cruelty under the law of any jurisdiction within the United States. So where do we stand with all of this? And here I'm going to argue that we have a few different categories of animal cruelty media. There's classic crush videos, the ones I described earlier in terms of Richard's injustice, and currently that is illegal and it can be prosecuted. Producing and trafficking those videos is prohibited under American law, and that seems to be upheld under Richard's injustice, relying on that unspoken Mishkin analysis. Then we have depictions of sex-linked cruelty, where animals are having, for example, their genitals injured, or animals are being sodomized. And I think that's really going to depend on the facts of the case. In some cases, you may get there under an erotic obscenity theory. In some cases, I don't think you will. And I think it would be very suspect to say that the entire category of that is going to be unprotected speech and therefore prohibitable. This bespoke cruelty content, these bespoke cruelty rings, whether the conduct itself is prohibited is really going to depend on the jurisdiction. There are individuals in Indonesia who have been prosecuted, arrested, charged once this ring was broken open, because a lot of this conduct is cruel under Indonesian law. The individuals in America who are paying for this content are not themselves doing the cruelty. So they can't necessarily be charged with a straight up violation of the PACT Act or of cruelty law. Prosecuting them under a trafficking videos theory, I think, is really difficult because you would have to argue that the video is erotically obscene. We know that violence against animals by itself is protected speech, is therefore not affected by current law. We also know that artificial crush, i.e., AI-generated animals or cartoons of animals, images involving fictional animals, is all protected speech. So to wrap up, because I know I'm going over time, where does this leave us? What do we do, and what are some arguments going forward? So in terms of addressing the conduct of real-life animals being subject to cruelty, the question is really, is the person doing the cruel conduct also the abuser in jurisdiction? If so, you can apply the PACT Act. Remember, the PACT Act makes it illegal for anyone in American jurisdiction to engage in animal crushing, the actual cruel conduct, in connection with interstate commerce. So the person doing the crushing, prosecutable there, also likely prosecutable under state animal cruelty law. As for the speech, so the recording of the videos, the transfer of the videos around the internet, that's going to require, again, a really narrow dive into what the facts of the case are, who the intended audience is, and what the impact is. And that's going to work best for sex-linked trafficking, crush videos, and so forth. On bespoke cruelty, I argue that the best approach is not to look at it as a speech issue, but to look at it as an animal cruelty issue and charge the people in the United States who are paying for these videos, who are specifically saying, this is what I want to see happen to a monkey, charge them with doing the cruel conduct under a conspiracy to commit or cruelty for hire theory. This might require some updated legislation, but I think we have good models under federal law. For example, the Lacey Act that makes it illegal to traffic wildlife that have been taken in violation of some other law. As for other areas of trafficking, in terms of the speech, I think it would be very dangerous to pass a law that says all depictions of animal cruelty are unprotected speech. You would have to overturn Stevens and entertainment merchants, and I don't think the court is going to go for it. B, that would make it very hard for those of us who are animal activists to discuss horrible things that are happening to animals that we want to address. For example, it would make it very easy for states to criminalize taking undercover photos of animals being treated cruelly or subject to maltreatment in farms, laboratories, and so forth. If there is hunger for arguing that there should be a new unprotected speech area for animal cruelty, I think the best way to do that is to be very intentional about defining what that looks like, how it operates in culture and science, and making that a descriptive category that applies to actual animals, describes the animals as victims, and explains why this isn't historically protected speech. I think there is a way to do that. I think you have to focus again on a real animal being harmed and that harm being intrinsically related to the cruelty. So I think that might work for bespoke cruelty videos. It's not going to work for example, second or third hand videos of news reports on animal cruelty. And to give you a hopeful note, I want to wrap up with this image. This is Mina. She was a sadly very popular performer in these bespoke cruelty videos. And when the ring was broken and Indonesian authorities arrested the people that were subjecting her to cruelty, she was taken to the Jakarta Animal Aid Network, where she's pending rehabilitation and released to the wild, and where I understand she is doing quite well. And that brings us to Q&A. Thank you.
Thank you, David. Thank you, Taylor. I know this is a heavy topic, so we definitely appreciate you guys sharing your knowledge with us today. We do have quite a few questions that have come in, and this is an opportunity. If anyone else has any more questions, you can submit them now via the Q&A icon. And we'll get started with one. There's quite a few talking about people, of course, being shocked with some of this. And we'll start with one simply: what can be done? What can people do to help make a difference with these videos?
I'll talk about my videos, and then do you want to talk about yours, Taylor?
Yeah, so mine are, I think, a little bit easier. A lot of is just being aware of what you're looking at and really thinking deeply about it. And if you see something, report it and be really specific about why you're reporting it, because the people who review those reports don't often know what they're looking at either, frankly. So as specific as you can be about those reports. There's also really specific, depending on where you are, jurisdictional laws about exhibition of wild animals and keeping wild animals. LA, for example, has very specific laws about keeping wild animals and the exhibition of them within that city limits. So being aware of those and knowing, find out where you can report cruelty, being mindful, and telling friends. Honestly, a lot of it for the more implied cruelty is saying, hey, I don't know that animal's really enjoying that.
I would agree with that. I think a lot of that applies to the kind of videos that I was discussing as well. I would say that if you are reporting these videos to a content provider, YouTube, Facebook, Instagram, whatever social media platform you happen to be on, it certainly helps to be clear about the fact that these are not just egregious videos, but in your opinion, they implicate a violation of a relevant law, because content platforms do have concerns about what the law is. And again, if it's a video of an animal being tortured that is eroticized in some way, colorably it falls within that crush video framework. Whether the individual video would or not is going to be something that would be up to US attorneys and the rest of us doing legal work. But I don't think you need to know that answer specifically to say, hey, this is creepy, it's disturbing, it's violent, and I also think it might be illegal, or I think it's worth you looking at the law. Beyond that, I think it's worth continuing to keep pressure on lawmakers to address these issues. For example, I think the best way to get at the kind of bespoke cruelty we saw happening to Mina the monkey is ensuring that we have laws that can target people in the United States who order up those videos as if they were ordering takeout by charging them with conspiracy to commit animal cruelty.
Okay, for this next one, so I'm asking about consent. Can the concept of consent be used in defense of animals since no consent is being provided by any animal? In the free speech defense, what is the alleged benefit of animal cruelty, child pornography, or dog fighting?
Yes, so the consent argument actually comes up a lot, not necessarily in the cruel video context, because I don't think anyone is arguing that the animals are consenting to being tortured to death. We see that argument a lot around state laws prohibiting sexual exploitation of animals, i.e. people having sex with animals. Because you are correct, animals can't legally consent. Therefore, that constitutes a sexual assault. In terms of videos of animal crushing, animal sexual exploitation, animal dogfighting, and so forth, there isn't a huge amount of argument that they have a high value. And I think it's instructive, again, to look at the differences between Ferber, which is the child pornography case, and Stevens, which is the Supreme Court animal fighting case, crush video case. In Ferber, the court says child pornography has a really low value and a really high harm, and we have no evidence that it's ever been protected speech. In Stevens, the court says it's low value, so that checks out. The court says it's a high harm, maybe not as high as sexual abuse of children, but still high. The difference is the court says we have no historical precedent of it being prohibited. And that makes it a lot harder to argue that it should be prohibited speech. This is a place where the court is not being consistent in how it deals with First Amendment jurisprudence. And I would argue where the court is engaged in a mistake that many of us as attorneys make. We believe that by virtue of having JDs, we are qualified to be experts on many fields outside the law. Here, for example, the court seemed to feel that they were qualified historians. The reality is that there are many, many examples throughout history of depictions of pre-adolescent children engaged in sexual activity with adults. And if the Supreme Court doesn't believe that, I can interest them in any amount of Greek pottery in museums around the world. Similarly, there's a long history of depictions of animals being subject to cruelty by humans. We see this in art, paintings, sculpture throughout the ages. I would argue that the court misses the point in how they construe this. It's not about, is there art that does this, and does society care? Instead, it is, was an actual child or animal harmed? It is impossible to make child pornography without abusing a child. It is impossible to make a crush video without abusing an animal. And I think that framing would get us to a more consistent First Amendment jurisprudence where the court says this kind of speech is inherently harmful, and therefore we can target it specifically. So we aren't outlawing Greek pottery in museums. We're not outlawing cave paintings of animals being hunted. We're outlawing actual humans and actual animals being subject to actual sexual abuse and actual torture.
So here's a good one, kind of related to compassion, fatigue, and balance. And I know something a lot of us experience, and acknowledging it's kind of hard to answer, but how do you handle having to witness such depictions of animal cruelty? Acknowledging it's necessary to be able to help animals and make positive changes, but of course must take a toll on you personally. So how do you struggle with that aspect of this challenge and these issues?
I know
That is a complex and difficult question. Wow.
I know from my perspective, when I was an active practicing litigator, I took a lot of comfort and solace in things that I did outside of work, but I absolutely took work home with me. It's hard not to, especially if you are a litigator and you're representing specific clients that have had cruelty against them, or if you're, combing through the SMAC report, which is grueling to look at, even for this piece of work that I was working on. It's disconnecting yourself, which isn't good for your clients and it isn't good for the animals, but maintaining and learning about yourself and learning how you process that information and how you can pull yourself out of it later. So it's definitely taking on that burden, that psychological and emotional burden, but that's why there's such high instances of burnout. So that I take solace in my kids and my companion animals, and I imagine other people do somewhat similarly. How do you handle the burnout, David?
I agree with all of that. I think it's really important for us to know our own individual limits and risk factors and triggers as well. For example, working in criminal law, I spent a lot of time talking to prosecutors and defense attorneys, and I know prosecutors and defense attorneys who will happily take on every case except not child abuse cases. I know prosecutors and defense attorneys who can do child abuse cases all day, but will never do an animal cruelty case. And that is a result of those people really spending the time to think about what is going to be the most tolerable or least tolerable for them. And I think sometimes we get into a culture of believing that watching something is valuable in and of itself. And I don't think that's accurate. If you're watching it to get something done, that is valuable. If you already know the horrible thing you're going to see and you can take action to stop it from happening, you don't need to keep watching it over and over. And that's certainly, I think that's something that we probably both experience in our work. We've both had to review some pretty awful photos and videos, but I don't put them on repeat. Once I've seen them and once I've done an analysis and I know what the legal issues are, I don't go back to that video unless it's legally relevant, because that doesn't do me any good. It doesn't do the animals any good.
Absolutely. All right, well, we are running out of time. Thank you everyone for submitting your questions. Thank you, Taylor and David, for spending time with us today. And thank you all for joining us and having such a great conversation. You will be able to view a recording of this webinar along with all of our past webinars on our website. If we didn't get to your question, feel free to send them to events@aldf.org, or you can also send them directly to David and Taylor and they will get back with you. Additional resources for this webinar will be made available on our website as well at aldf.org/webinars. We would appreciate it if you could take a moment and complete the survey that will pop up on your screen to help us in future planning. You might need to click a blue continue button to access it. And this is our final webinar of 2023. So we really hope that everybody out there has a wonderful holiday season. We appreciate all of the ongoing support for the animals, and we truly could not do this work without each and every one of you. So thank you for your support.